Tip 1. A question from Cassandra. I am currently in the process of registering a company for my SaaS. My co-founder is not at all contributing much. I want to structure my company in such a way that he will get equity only if he contributes. Is there any way I can do this? Absolutely. You can structure equity to be conditional on actual contributions. One common approach is to use stock options or equity grants tied to specific milestones, like hours worked or deliverables completed. That said, if you're unsure about your co-founder's involvement, it might be safer to start with 100% ownership and only issue equity once contributions are made. This avoids complications down the line and keeps you in control early on. Just make sure everything is clearly laid out in a formal contract, and ideally have it reviewed by a lawyer in your jurisdiction. It's a small step that can save you a lot of trouble later. Tip number 2, a question from Landing Page. Great name, by the way. What is the best way to protect my application, idea, and code while my SaaS is still small? I don't want one of the big players to steal my idea. I have some features that are unique on the market. Okay, that's a very common concern and a valid one. When it comes to protecting your SaaS product, there are really two main strategies outside of branding: patent and commercial secrecy. Patents can offer a strong protection, but they come with a price. The process is expensive, varies country by country, and requires you to publicly disclose your code. And even if you get the patent, you'll still need the resources to enforce it if someone infringes. Most early stage SaaS companies opt out for commercial secrecy instead. That means keeping your source code tightly controlled and using strong legal agreements like NDAs and IP assignment clauses with anyone who touches your product. It's a more affordable route, but it won't stop a well-funded competitor from replicating your idea. If your features are truly unique, it's worth thinking about both options and maybe even talking to a lawyer to weigh the risks and benefit. Tip number 3, a question from ClickMagnet. Trademarks relation to name on Play Store and App Store. How much are they enforced for general things as name? Like if I have an app called Textbook or Elephant or Pigeon, do I risk getting served if my app grows big? Yes, you absolutely could run into trouble. Even if a name sounds generic, it might still be trademarked in your target market. That's why it is crucial to do a trademark search before you commit to a name. For example, in the US, you can check the USPTO database to see if a name is already registered. It's a simple step that can save you from a legal headache down the road. In Canada, you can look into the Canadian Trademarks database, and in the UK, the Intellectual Property Office. Tip number 4, a question from Karsh2424. Can you use client logos on your website who are using your services? Example, a big company who signed up and paid for the app. Do you have to ask them for permission? I know it's the best practice, but is that a legal thing? Yes, and it's not just best practice, it's a legal requirement. Using a client's logo without permission can be considered trademark infringement. To do it properly, you need to get a license to use their trademark for marketing purposes. This is usually handled during contract negotiations, or it can be requested later, ideally once the client is happy with your service. So a follow-up question from Asselby: is it something you can just add to your terms of service and when they sign up, they agree? You can definitely try. Including in your terms of service is a smart move, but be aware sophisticated clients will often review and negotiate your terms. They definitely will push back on any blanket license to use their IP. That said, not all clients are sophisticated, so it is worth including by default, and maybe you'll get lucky. Tip number 5 and 6. A question from Born to Cook Now. Thanks for doing this AMA. I have 2 questions. First, what is the legal mistake you see founders do again and again that could be easily avoided? Second, if a client asks for a refund despite terms of service indicating that refunds are not feasible, is it better to take the hit and give the refund to avoid any potential legal headache? Those are 2 great questions. Let's break them down. First, the most common legal mistake: founders jumping into business together without a shareholder agreement. It's like getting married without a prenup. When things are going well, no one wants to talk about it, but when things go south, it's too late. So a simple agreement that defines roles, responsibility, and what happens if someone wants out can save you from a world of pain later. Second, should you issue refunds even with a no refunds policy? Well, it depends on who your customer is. If it's an individual, consumer protection laws might override your terms of service, so you need to tread carefully. If it's a business and they clearly accepted your terms of service at the time of of the deal, you're on firmer legal grounds. That said, always weigh in the legal risk against customer satisfaction and the potential for a breach of contract claim. It's a case-by-case decision. Tip 7. A question from Realistic Slide 3931. How should early stage companies go about making sure the terms of use and privacy policies are solid? How does the answer differ from customer bases in EMEA, US, and Asia? That's a fantastic and complex question. The right approach really depends on how your SaaS operates and what kind of data you're handling. If your platform processes personal information, then privacy laws become a major concern. These laws vary widely by region. The safest route? Follow the strictest standard. Usually that's the GDPR in the EU for privacy laws. So if you're compliant with GDPR, you're likely in good shape for many other jurisdictions. But of course, there are always exceptions. As for the terms of service, B2B agreements tend to be fairly standardized across borders. The real complexity comes in if you're selling B2C, where consumer protection laws can vary dramatically. That's really where you'll want to be extra cautious and possibly seek legal advice tailored for your market. Tip 8, a question from OKMud945. What policies or legal docs can you write up for my business that ChatGPT can't generate for me? That's a great question and one I get a lot lately. Tools like ChatGPT or Copilot can be incredibly helpful for getting started. They're great for drafting simple service agreement or basic policies, especially for small scale or low risk use cases. But when it comes to complex, high stakes contract like a 100-page SaaS agreement with a major enterprise client, AI just isn't there yet. These documents require deep customization, legal nuance, and an understanding of your specific business model and risk profile. So yes, use AI to get the ball rolling, but when it really matters, you'll want a lawyer that can tailor the contract to your exact needs. Tip number 9, a question from Particular Being 6853. What are some of the most important considerations to make when initially kicking off a SaaS product? A lot of folks are starting to utilize no-code or AI code vibing to create basic solutions. What should they be considering while doing this? It's a fantastic question and a very timely one. One of the most valuable assets a SaaS company creates is its intellectual property or IP. So if you're using no-code platforms or AI tools to build your product, you need to be absolutely sure that you own both the input and the output. That means checking the terms and conditions of any tool you use. Major platforms like OpenAI are generally solid. They explicitly state that you retain ownership of your input and they assign you the rights to the output. But smaller and more sketchy tools, they might not offer the same protections. Bottom line, before you build anything critical on a third-party platform, make sure it doesn't quietly claim ownership of your work. Your IP is your crown jewel, protect it. And final tip for today, a question from Brian Brady. Is there a standard contract template that all SaaS contracts should use? If so, what are the issues that you see missing from agreements that have you annoyed? That's a great question and one I hear often. While there isn't a one-size-fits-all SaaS contract, I have developed a basic template that has helped close a lot of deals. That said, every SaaS business is different. Some handle sensitive personal data, others offer implementation services, and some even deal with health information. So customization is always necessary. But because I like free stuff, I have prepared a free B2B SaaS template for you, which you can access with the link in the video description below. Now, one issue that really worries me, contracts that don't include a limitation of liability. I see this all the time with startups, and worse, big companies often pressure smaller vendor to remove those limits entirely. Here's the risk. Imagine signing a $10,000 deal, but without a liability cap, you could be sued for $1 million. That's a fast track to bankruptcy. So yes, use a solid template, but always make sure it includes strong liability protection. So that's it for today. If you found this helpful, don't forget to smash that like button, subscribe for more legal insight tailored to SaaS founders, and drop your own questions in the comments. I may just feature you in the next video. You can also find me on Reddit at ThatITLawyer, where I'm always answering questions like these. All right, stay smart, founders, and I'll see you in the next one.